What is a power of attorney and why should you know about it? Hi there, my name is William Ha. I'm an estate planning attorney in California. I do wills, trusts, and I help people avoid the probate process. Quick disclaimer, I'm only going to be giving you guys legal information, not legal advice. So if there's something specific to your situation, or if there's something that you're not very clear about, I suggest you seek the advice of an attorney. A power of attorney, or a POA, is a legal document that allows somebody else, aka an agent, sometimes it's also known as an attorney in fact, to act on your behalf on legal, financial, or personal matters. Whether you're planning for the future or you're looking for somebody to manage your affairs temporarily, having a POA is very handy. It's important to note that a POA is only good until the signer dies. Once that happens, the authority of the power of attorney dissolves and it ceases to exist. For authority to act on behalf of somebody who's passed away, you'll need, generally speaking, authority from the probate court. In the state of California, there's a document called the Uniform Statutory Power of Attorney form. This is a standardized document that makes things a lot easier to make a power of attorney. It's pre-written and it's a template and it covers most common financial and legal decisions. But it's important to know that this only covers those types of decisions, but not healthcare. If you're looking for a form that gives somebody else the power to handle your healthcare matters, the form you're looking for is called an Advanced Healthcare Directive. You can easily find that form by searching for California Advanced Healthcare Directive form. Who should you choose to be your agent or attorney in fact? This person typically has a lot of power over your financial life, so it's really important that you choose somebody who you trust completely. Generally speaking, people choose their partner or their spouse, maybe a really close friend. You'll also want to make sure that this person understands your exact wishes and that they're willing to carry it out. Now, let's talk about the key sections of the California Power of Attorney or POA form. First, you'll write your name. And secondly, you'll nominate your agent, and you'll also nominate backup agents just in case the first primary agent is either unwilling or unable to serve as your agent. Then you'll indicate what powers you want to give them. There are really broad categories like real estate, taxes, banking matters. You could also add specific instructions to limit or expand the scope of any of these powers. One thing to keep in mind is the default setting for the form as to when the power kicks in, it's immediate. This means that the agent, once you've signed the form, can act on your behalf right away, even if you're fully capable of acting on your own. So if you want the POA to take into effect only upon your incapacity, then what you're looking for is a springing power, as in the power springs into action once that condition is met, either be it incapacity or that you're missing for a week. To make it official, you'll need to sign the form in front of a notary public, who will then acknowledge your signature. Once it's signed, keep a copy for yourself, give copies to your agent and any backup agents, and also give a copy to any institutions who will be interfacing with the agent on your behalf. It's also important to know that because it's such a powerful tool, you have to know exactly what you're signing away. You should also know who it is you're nominating to become your agent. You have to trust them. It's also really important to note that you could always revoke your power of attorney form. You could either sign a revocation or you could sign a brand new form that gives the power to somebody else, in turn revoking all their previous forms. This is what the power of attorney form looks like. The best way to search for it is to search for LA County Statutory POA, and this is what you'll be getting. I will be dropping the link down in the description below. So the first thing you're going to notice is that there's this gigantic block. It's a disclaimer. It's basically saying that this document is it's a dangerous document. Whoever you give this power to, they could do quite a bit. And that if you have any questions, you should talk to an attorney, and that ultimately you can revoke this power of attorney later on if you wish to. So let's go ahead and dive right in. The first blank is where you put your name. So it's I, your name, and address, appoint the agent, the person who you want to manage your affairs, along with their contact information, their address. And you want them to act for you in any lawful way with respect to the following initial subjects. So here in this section, you have blank lines from A to N. If you want them to have a specific power, you initial that line. If you want them to have all the powers above line N, then you just need to initial line N. You could just ignore the rest. So for example, let's say you want someone to pick up your apartment keys on a apartment rental you're renting, but you can't be there at the time. You can use this form, initial line A, and specify under special instructions you want them to be able to pick up your keys on your behalf, and you want them to be able to interface with the movers to move things into the apartment. You can do that. You can give them the power in real estate, limit that power to that situation, and this power will only be good for just that. This special instruction block allows you to limit or expand the power granted to your agent. In this block as well, you could specify whether or not you want this power to kick in immediately. If you do nothing at all, the power is kicking in as soon as you sign this document. There's this line here, it says this power of attorney will continue to be effective even though I become incapacitated. You might be thinking, like I said, I thought this was the whole point, to handle incapacity. Yes, it is, generally speaking. So this line is what makes this power durable, as in the power survives incapacity. Otherwise, it would last until death. If for whatever reason you don't want the power to survive incapacity, meaning you want the power to stay in effect until you become incapacitated but not dead yet, if you want that to happen, then you basically just cross that line out. If you cross this line out, you're essentially saying that if I become incapacitated, then this power is actually no good anymore. And that's this instruction here. That's what it's telling you to do. Strike the preceding sentence if you do not want this power of attorney to continue if you become incapacitated. All right, so if you happen to have appointed more than one agent to act at the same time, you need to specify whether you want those agents to come to agreement and come to an agreement jointly, or can they act separately on your behalf? So say, for example, you want to give people the power to purchase supplies for your business while you're away, right? Then you give two assistants that same power. Do you need those two assistants to both sign on the contract when they're ordering supplies for your business, or can they act separately? If they can act separately, then just go ahead and write separately here. If you want them to both sign on agreements, then you write jointly here. I do want to note that revocation of this power of attorney, meaning your wish to just rip it apart and have it no longer be in effect, it's not effective unless and until that third party, that person who might be interfacing with the agent, has actual knowledge of this revocation. If you are going to sign this power of attorney document and this agent now has the power, and then 2 weeks later you decide that you want to revoke this power and you sign another document revoking this power, you need to give that revocation notice to that third party who may be relying on that initial power of attorney document you signed. Essentially, ideally what you would do is you would revoke the power of attorney, let the agent know that it's been revoked, that they can't act anymore, and then let that third party that the agent who's been interfacing with know that agent can no longer work on your behalf or represent you. So that third party could be like a bank or a financial institution, could be an attorney, could be the IRS. Once the above spaces are filled, just sign date in the state of California, County of Los Angeles, and then you sign this in the presence of a notary. They acknowledge your signature, and then that's it. That's your completed statutory power of attorney document. If you have any questions, my suggestion would be to seek out advice of an attorney. There is actually quite a wealth of materials out there for you to learn about a power of attorney online as well. That's my suggestion if you need something like this done, to have someone else handle your affairs while you're either gone, away for a bit, or just in case when you are going to be going through some form of incapacity. Thank you for watching.